Hello, Badm 107 students. This is the video for the review of last year's exam in preparation for this year's final. My apologies, it was supposed to be uploaded yesterday. I attempted on 2 occasions to do it. Unfortunately, I mowed the lawn and I'm allergic to 7 different types of common grass. As a consequence, when I tried to do my video, I lost my voice. Hopefully, I'll be able to hold on to it today, although it still doesn't feel all that great. Anyway, this will be our last video unless there's a problem. I want to do 3 things. First of all, I want to make sure that we do the IP problems so that you get some better understanding of how intellectual property matters will apply to not only real life but the exam, which is more important to you right now. And then I'm going to go over last year's final exam. I'm going to talk about the lecture materials that you should be aware of. And I want to talk about one question on the quiz. Okay, and I think I'll start with it. For the most part, actually, when I'm recording the grades, most people did okay. I mean, if you got 13 out of 30, okay, you go, oh, I didn't do that well. Well, yes, you did, in the sense that you got 13 out of 15 as far as the marks go, okay, because I built in that other 15%, or pardon me, 15 marks. So if you got 20 out of 30, which one student did, kudos to David Hernandez, and there was one student who got 22 out of 30, kudos to Victor Bellick. Well, those students get the 15% grade, plus they get, well, let's use David's example. He gets his 15%, plus he gets another 5 bonus marks towards the final. Okay, so I think everybody picked up some ground, or at least most people did. But there was one question that was answered terribly, absolutely terribly, and that's how to set up signature lines. First of all, it was done extremely poorly on your quizzes, and secondly, even though I went over it and said, oh, this is going to be on the quiz, or pardon me, it was done really poorly on the contract assignments, and then even though I went over it and said, oh, this is going to be on the quiz, there's about 3 students who actually answered it, and 2 of those were good and 1 was okay, and the rest of you left it blank, gave up 6 marks just like that because you don't pay attention. Anyway, it's going to be on the final. It's going to be on the final. It's going to be on the final. Why? Oh gosh, because I'm just a mean instructor. No, actually, it's going to be on the final because out in the real world, when you're doing a contract, the last thing you want to do is go through the whole problem, get it signed, and then find out you've got the wrong party. Okay, oh, the contract is useless. Well, this is something that you should remember for life. I've got to bring it up on my screen here. One sec. Ooh, I can't do that. All right. Not, and continue recording. All right, it was Benton Counter of Peak Performance Pontoons getting a bank loan, all right, for his corporation. And then there was Gil Bates from Microhard, okay, who was getting a loan. And the bank wants to make sure that those contracts are binding, okay? Oh, there's offer, there's acceptance, there's consideration, there's intention, there's legality, there's, capacity. And, all that's there, and we forgot to get the signatures done right, so all that work is for nothing. It will be on the final. It will be on the final. It will be on the final, and it will be mandatory, okay? Benton Counter is signing for the corporation. So there has to be Peak Performance Pontoons, Inc., per a line, and then underneath Authorized Signatory. He's signing for the corporation. Oh, good. Whew, we got him. No, you don't. You've got the corporation, but you don't have him, so you've got to get a personal guarantee from him. Why? Because he's not getting any consideration, okay? The loan is to the company, okay? So he's not getting any consideration. You have to have him sign a guarantee. So there should be another line, and there should be one of those little red dots beside his name. Why? Because that means he'll be bound to the guarantee, even though he's not receiving any direct consideration. All right? Okay, Gil Bates. Oh, well, we'll put microhard per. No, you cannot do that. Microhard does not exist. It is merely a trade name. You have to get Bill Gates. So you have a line with Bill Gates or Gil Bates underneath it. Do you need a seal beside it? No, you don't. It won't be incorrect if you put a seal beside it, so I wouldn't take marks off, but you don't need it. Why? Because he's primarily liable. He's signing for the bank loan. So get a guarantee. He's liable, so you don't need it, okay? So that will be on the file. All right, that's enough of that. I've ranted and raved because I was really disappointed. IP practice problem. This is on eLearn. Hopefully you've done it. Hopefully you've looked at the chapter. If you haven't, then you're going to run into my exam like a brick wall. There will be an IP problem on the exam. Why? Because it's important out in the marketplace again. All right. With the extreme sport of whitewater skiing becoming more and more popular, blah, 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 Garnet Gadget creates these goggles, right? So you go through the problem and you say to yourself, he developed a set of attractively shaped lightweight goggles. Oh, I was just putting in some verbiage there to fill up the paragraph. No, attractively shaped, industrial design. The shape of an object can be protected if it's unique, okay? If you have a sailboat hull, and it's exactly like somebody else's, that's not unique. But if you have a unique sailboat hull that makes your sailboat faster than others, you can register an industrial design on it. Okay, so that's number one. Okay, uniquely ground lenses. Uniquely. The second you see that, you've got to realize that this is a potential patent. Patents have to be unique, ingenious, and have utility. All right? So obviously it's ingenious because he's invented it. It's unique. There's nothing else like it on the market. And it has utility because it works. So you get a patent on the ground lenses. That's two things. To deal with the whitewater spray, he develops a small, unique battery. Oh, unique battery. Oh, no. There's already a patent in this problem, so there cannot be a second patent. Why not? Okay, so there's a second patent on the battery. Then you could probably even say that the whole invention together is incredibly unique. So 3 patents, all right? 3 patents, 1 industrial design. We've got 4 things, and you only had to do 5. Going on, require the drafting of an operations manual. Copyright. Okay, you get a copyright on the operations manual. The glasses are called Gladiator goggles. Oh, gee, there's a unique name, right? So you want to get a trademark, but you have 2 types of protection here. This will be on the exam, and I don't know how many of you will not listen to me right now, but if you do, you'll get 2 marks instead of 1. You can you can protect a trademark 2 ways. You can sue for the tort of passing off, okay? And you can also register under the Trademarks Act. If you can sue for passing off, why do you register? Well, you get wider protection under the statute, okay? So there, we're at 7 different things, all right? If you have any questions about that, just email me. Okay, let's run through the lecture materials, because it's, those things that you were supposed to buy that a lot of you didn't, apparently. There are pages called the Partnership Act and the BC Business Corporations Act, okay? You can bring everything into the exam with you because it's open book. But the point is, these will be helpful in answering some of the questions in Part B and in the Part C problem. Oh, good. Then I'll wait until the exam, and then I'll try to find the relevant section. Let's see, where is it? Let's see, where is it? You don't have time for that, folks. You should familiarize yourself with this beforehand. For example, one of the things that has been on previous exams, and I can't remember if it's on yours or not, but I don't think I went over it when I was talking about corporations, and that is directors and officers have to qualify to be directors and officers. So Section 124, for example, says you have to be over 18. You have to be not an undischarged bankrupt, so they don't want people like President Trump who go bankrupt and start another company, go bankrupt and start another company, go bankrupt and start another company, screwing their customers all along the way. So they say you cannot be an undischarged bankrupt. You cannot be convicted of an offense of fraud within the last 5 years. Okay, so you got to familiarize yourself with those. What else? Let's see. Is there anything else in here? That's probably only material that you really need to know, although there is some material in there about sexual harassment and the Human Rights Act and questions you can ask during a bank interview, a job interview. So just make sure that you familiarize yourself with that and have it handy for the exam. All right, on to last year's exam. Part A. I'm going to go through these really quickly. Why quickly? Because I do not use the same terms 2 years in a row. There's too many of them, so why would I do that? And I'm using an exam from a student, and there's so many errors in here, it's terrible. A covenant. What's a covenant? A covenant is a guarantee signature in a lease, okay? Fiduciary relationship is O. Defalcation is theft by employees, okay? Wrongful dismissal is when you fire someone without providing the correct notice or pay in lieu of notice. Insurable interest is J. A grievance is under the collective bargaining, which is union management relationships. There's a dispute during the course of a valid collective agreement, and the grievance goes to the arbitration with the Labor Relations Board. The next one, collective agreement, is just a contract of employment between management and a group of employees instead of a term contract or a contract of indefinite hire, which is between master and servant. Okay, so if it's not a union situation, the employer has a contract with each employee. Under collective bargaining, the employer has one contract with all the employees. Okay, public domain is C. Good standing is when you are up to date with all your filings at the registrar's office in Victoria for your corporation. You have to file an annual report. You have to have a director's resolution, a shareholder's resolution every year to keep your corporation in good standing. If you don't, it can be struck off the register. Insider trading is when you, as a director, officer, or some other designated person, have insider knowledge about something that's going to happen in the business corporation, and that means the shares are either going to go up in value or down in value. You saw that in the United States very recently. There were a lot of senators who Trump called up and said, "Hey, look, there's, the stock exchange is going to take a dive here," and they all ran out and sold their shares. Okay, and now some of them are being charged with an offense. Moral rights is looks like this person said F. What the heck is F? Yeah, F is correct. You can protect your work. For example, an artist does a statue, and somebody wants to take the statue and paint funny faces on it because they bought it and they have copyright now. They cannot do that. Okay. Ratification. Perfect example of this is a pre-incorporation contract. Someone is about to incorporate a company and rushes out because they're eager to get going, and they they sign a contract with a supplier, okay, or a contract with a landlord, and the corporation is not yet incorporated. Well, if everything falls flat and the incorporation does not take place, that pre-incorporation contract will mean that whoever signed it is liable. Why? Because it'll be peak performance pontoons per authorized signatory, and Benton countersigns it. But if there's no corporation, then you take off the corporate name. If there's no corporation, you take off the per. If there's no corporation, you cannot be signing on behalf of it as an authorized signatory. That leaves his signature. He's liable. However, if he signs a lease and the corporation is finally incorporated and begins to pay the rent, then that contract has been ratified by the corporation, and Benton Counter will no longer be personally liable, even though he signed that lease in advance of the corporation coming into existence. Minute book is, boy, this P, I guess. Yeah. Minute book is P, and then pre-incorporation contract is. Boy, this person's writing is pathetic. H. Okay, so that's part A. Part B. On last year's exam, it said you are required to answer question 1. Question 2 is optional for 2 bonus marks. This year that will not be the case. You will be required to answer question 1 and question 2, and you can probably guess that question 2 will be something about signature lines. Okay, so here this was a problem. Now, question 1 in part B can be a problem like this on partnerships, but I did it last term, so I'm not likely to do that one again this term. It could be on corporations. It could be on HR management, or it could be on intellectual property, or it could be an insurance one, all right? A pretty heavy hint, we spent a lot of time doing HR management, so I think it'll either be an HR management one or an insurance one. Let's just run through this, though, because partnerships could turn up in the next part of the exam. Okay. Daisy Bloom, Pete Moss, and Rosebush form a partnership or form a business to do gardening, all right? They go in to see their lawyer, and the lawyer says what type of operation they have. Well, it's not a sole proprietorship, right, because there's 3 of them, and it's not a corporation because the name doesn't end in LPB, LTD, Inc., or Corp., so that leaves partnership. So it's a general partnership formed pursuant to Section 2 of the, here's a toughie, Partnership Act. And he recommended that they have him prepare another document. Another document. What would that be? Well, if you have a partnership, there should be a partnership agreement. If you have a corporation, there should be a shareholders agreement. So this is a partnership agreement. They then subsequently changed the nature of their operation to bring in some additional investment. Uncle Philodendron invests in the business but doesn't want to be liable. How do you do that? You set up a limited partnership. Okay, Uncle Philodendron becomes the limited partner, and the other 3 become the general partner. All right, in the next paragraph, one of them decides to do a little bit of extra gardening on the weekends and not tell the partners, and when the payment's made, it'll be cash and he'll take it in his pocket. He's running afoul of Section 32 and Section 33 of the Partnership Act. Oh my gosh, golly gee, how am I going to know that? Well, that's the Partnership Act that you can bring in with you to the exam and look at, so you should be able to figure that out. Daisy and Pete were glad. Rose forgets to put the brake on the truck, and it rolls down the hill and causes $342,000 in damages. And Daisy and Pete went, good thing it was her and not us, because she's negligent, so she'll get sued. She'll be liable, but we won't. Problem with the partnership is that you are all jointly and severally liable for the torts committed by one of the partners. So that means that they will be jointly and severally liable and have to pay. Now, Philodendron, of course, was a limited partner, and so he's not liable. He loses the money he has invested, but he doesn't lose any more. And that's not correct, because he got involved in management when he did the marketing study. So pursuant to Section 64 of the Partnership Act, he loses his limited liability status and becomes generally liable. All right. That's question 1 in Part B. Question 2. We've got Bernard Belcher of the Far and Near We Make and Ship Beer Here and There and Everywhere Corp. And the bank will want his signature set up as it's shown there. And everybody signed it last year. That's just showing you what the lines were like. I didn't ask anybody to sign it, but what the hey. Then you explain what the per means on behalf of. Okay. Authorized signatory. Oh, it means you're signing as an authorized signatory. No, what that means is, in the world according to Peter Holden, put per there, but also put authorized signatory there as one more way that the judge cannot hold you personally liable. You're not an authorized signatory for you, so you must be an authorized signatory for someone or something else. Why does he have to sign twice? Well, he's signing for the corporation to begin with, and then the second one is he's signing a personal guarantee because the bank will want one. You put a red seal beside it. Why? Because he's not getting any direct consideration, so it has to be under seal or it's not binding. Okay, question 3. There are potentially 4 types of labor disputes. That was from the old textbook. In my textbook, I think I talk about this in a better way. So there are 3 types of labor dispute. And there's those that occur during the initial period when you're trying to set up a union, and they're generally called certification disputes, and they're solved by the certification procedure. Then the second dispute is the negotiation disputes, when you're trying to get a collective agreement. How are they resolved? By the process of collective bargaining outlined in the Labor Relations Code. Then there's contract disputes. This is when you have a collective agreement and there's a grievance under the contract dispute. How are they resolved? They're resolved by arbitration before the Labor Relations Board. The statute, I've already mentioned it, the Labor Relations Code. Okay. The next paragraph is you are entering into a corporate business venture with Billy Bob Bodine, Billie Jean Bodine, and Gary Greed. You are concerned about becoming a locked-in and frozen-out shareholder. The problem can be avoided by having your solicitor, Reynold Rush, of the firm of Rush, and Delay, prepare a, you got a corporation? Shareholders agreement. And then what you do is you put in specific clauses. You put in a clause that says you all have a right to management, which means you're on the board of directors. If you're kicked off the board of directors, you can appoint yourself again. You have a right to employment. You're an officer of the corporation. If they fire you as the vice president of sales, you can appoint yourself back. But then that's fair to one side. The other side is you'd better have a default procedure where if somebody's not carrying their weight, you can call them in default and say you've got 60 days to 30 days, 2 weeks, whatever you want, to repair the default. Failing that, the company can buy back your shares at a discount. Well, that's not fair. I mean, you might want to say, okay, I'm in default, but I don't want to do this, so I want to sell my shares. So there should be a clause in there saying you can sell your shares. However, there has to be a right of first refusal, which allows the other shareholders, directors, and officers to buy your shares before you sell them to somebody else. Okay? Bailment. What is bailment? And explain the term bailment for value and gratuitous bailment. Bailment is the transfer of possession, not ownership, of something from one person, the bailor, to another person, the bailee, subject to it being returned in as good a condition or better, or disposed of in accordance with the bailor's wishes. Okay, gratuitous bailment, gratuitous promise. Remember that? Oh, gratuitous promise. What happens in a gratuitous promise? Well, it's when I promise to give you my car. It's not a binding contract, even though I make that offer and you accept it. Why? Because you're getting consideration. You're getting my car, but I'm not getting any consideration. That's a gratuitous promise. Same thing here. You borrow somebody's textbook. They are the bailor. You are the bailee. You have to get it back in as good a condition as you received it. But you're getting consideration. You're getting to use the textbook, but the other person isn't getting any consideration, so it's a gratuitous bailment. Bailment for value is when you go and give your watch to somebody to be repaired. You want to get it back in better condition, okay? So you get the watch back fixed. That's your consideration. You pay the watch repair person some money. That's his consideration. Okay, the business has an unregistered trademark called Power Plunge and can sue the infringer for passing off. What are the two reasons why the business might elect to apply to register Power Plunge trademark instead of just suing for passing off? Why register? Well, because passing off is only protection in the area you serve, whereas if you register under the Trademarks Act, you're protected all across Canada, and under the USMCA, which is the United States-Mexican-Canada Agreement, which replaced NAFTA, you're protected in those two countries as well. The other reason is you have two remedies. If you sue for passing off, injunction and damages. But if you have registered, then you actually have 5 remedies. I don't ask you to know the remedies, but I ask you to know that there's 5. Statute? There's a toughie. Trademark Act. Okay, Peter writes a book, all you ever wanted to know about the law and then some, and he automatically has copyright in the book. Why might he wish to register copyright under the statute with the and under what statute would the registration take place? If I registered, I'm immediately protected in 130 countries in the world under the WTO, the World Intellectual Property Organization. And the other reason is if I have copyright and you copy my work, I have to prove I have copyright and then sue you for copyright infringement. Whereas if I've registered it, I don't have to prove I've got copyright. You have to actually prove I don't. Okay, if Peter transfers all right and title on his book to the Regal Legal Publishing Company, could he do anything if the publisher decided to change his serious legal work into a legal joke book? Yes, in Canada. I have the moral rights to the integrity of my work, which means you cannot change it. You can make 100,000 copies and give them away. You can keep it and never sell a copy, but you cannot change my work. Okay, the existence of a corporation as a separate legal entity is said to provide limited liability protection to members, which are now called shareholders, directors, and officers. They are said to be protected by the corporate veil. Yet some 12 situations in which the corporate veil may be pierced or circumvented, causing personal liability, have been discussed. Indicate 3 situations in which the corporate veil might be pierced, and indicate 2 types of exposure of liability which still make it a good idea to incorporate. This is that diagram I had with all the lines going back and forth, piercing the corporate veil. If you get a bank loan, you sign a personal guarantee, so the bank can go behind the corporation and go after you. Those are the kinds of things. Okay, so you just list some of those. The important thing here, I mean, you got that list. You can just look at them, right, and figure them out as long as you understand them. But why is it still a good thing to incorporate? In actual fact, this is from last year. I've added 2 more things to the list. So there's like 14 reasons why the corporate veil can be pierced or circumvented to make directors and officers liable. What is the point then in incorporating? 2 reasons. Number 1 is nowhere on that list does it say torts. Okay, so if an employee commits a tort and the corporation goes bankrupt because of the liability, the person that committed the tort is liable, obviously, and then the corporation is, but they can't say, okay, Peter, you own the corporation, so you're liable. I'm protected. Okay, and then the other reason is you enter into contracts with suppliers, you enter into contracts with customers. These contracts are between those people and your corporation. They are not between them, your corporation, and you, and so you are not liable on those contracts. Only your corporation can. So there's 2 very important reasons why the corporation should, or why you should still incorporate a company. Okay, a business person, you should have 5 documents to keep your estate in order. The first is a last will and testament. It speaks only from the date of death, and it says who gets your assets. If you don't have that, then your assets are all sold and the money's divided up between the closest blood relatives. Well, I might hate my relatives, so I want to leave everything to somebody else. I can do that if I have a will, but I cannot do it if I don't. Okay, then you want to have a power of attorney for your business so that if you pass away, somebody runs your business, keeps it an ongoing concern, and then you can sell it for the value as an ongoing concern rather than the value of the assets. For example, when I had my law practice was quite valuable. But if I passed away and did not have a power of attorney allowing somebody to run my law practice for me, I turn out and sell what? My cabinet and my photocopier and 2 computers and some stationery. All used, well, except the stationery, almost no value. But my client base is very valuable. That will evaporate if I don't have somebody that can take over. Now, power of attorney for personal matters. The reason that is in there is because I give a power of attorney to my wife to do my banking and to do, financial matters and write checks and pay bills and things like that. But she could not run my law firm because she's not a lawyer. Okay, so, but I wouldn't want the lawyer that's running my law firm to do my personal banking. Okay, so you may have to have 2 powers of attorney, one for your business and one for personal. Representation agreement, you designate somebody to be a representative in the event that you are incapacitated. They can make medical decisions for you. Pull the plug. Okay. And then the last one is a comfort letter. This is not a legal document. It's something that should be updated periodically. You just list where your assets are. Okay, I've got this at that bank, and I've got this at this financial institution, and I've got these GICs, and I've got my will is in the safety deposit box with the humongous bank. All those sorts of things, okay? And then the last question is not going to be on your exam. I said list and briefly explain 5 valuable concepts you learned in the course. And it was amazing how many people said, gee, I don't know, I can't remember. What did I learn? Left it blank. Anyway, that is part B. And I put on a bonus question. It showed hotel workers take to the streets after late night talks break down. How would this labor dispute be resolved and under what statute? 1 bonus mark. This is so easy, I couldn't believe it. Most of them didn't answer it. Obviously, they're negotiating a collective agreement, so this has to be a negotiation dispute. Okay. And it's resolved by the collective bargaining process, and under what statute? Oh my gosh, what could it possibly be? The Employment Standards Act. No, it's got to be the Human Rights Act. No, it's got to be the Business Corporations Act. No, it's got to be the Labor Relations Code, okay? Anyway, Part C. This is a relatively long problem. Okay, how do we attack this? Anyone watch The Big Bang Theory? It's a comedy show on TV, and it's got Sheldon Cooper and Howard Wolowitz and Dr. Rajit Cooper-Pauly. So I just used it and wrote a problem around it. Okay, so Sheldon Cooper got his doctorate degree at 16. Now he's 32 years of age. He worked at the Central BC University and Institute of Technology, where he's been employed for 9 years. Why would I be saying that? 9 years is important. Leonard Hofstadter has been employed for 6 years. Dr. Rajit Cooper-Pauly is just a visiting professor, and he's only been at the university for a very short period of time, 2 months. And then Howard Wolowitz is a veteran employee working for NASA, and he's been there for 9 years. So obviously one of the things is they get fired, and the question is how much notice should they have received, right? So Dr. Cooper has been there for 9 years. The Employment Standards Act lists the minimum. The common law, judge-made law, lists the maximum or allows for more. So under the Employment Standards Act, it's 9 years, so he gets 9 weeks, right? No, 8 weeks is the maximum you can get. If you've worked there for 8 years, you get 8 weeks. If you've worked there for 9 years, you get 8 weeks. If you've worked there for 12 years, you get 8 weeks. So the maximum is 8 weeks. Longer, 1 month per year of service is the rule of thumb that we're using for this class. It's not used in every managerial, professorial, professional situation, but it's a good guide. So 9 years, 9 months, okay? Dr. Hofstadter, well, he's been there for 6 years, so he gets 6 weeks notice, right? Longer notice, 6 months. Dr. Cooper-Pauly, 0 and 0. Why? Because the next blank down says, Howard asked why Rajit was not entitled to any notice and bellowed because he was still on probation, okay? Generally 3 months probation. All right, let's back up. Okay, so they come up with this idea for a time machine, and somebody accuses them of stealing their idea. Who is it? Dr. Murdley Gertson says, they stole my idea, I'm going to sue them. Can't. Why? Because an idea is not subject to theft. If you have a patent, so you have a working prototype, you could be sued if you infringed it. But an idea, not subject to theft, so the case is dismissed. The lawsuit was frivolous, so when they fired you, they didn't have just cause. We sued them, the university, for 2 things: damages, reinstatement. Okay, those are the remedies for wrongful dispute. What statute provides the maximum? We've already talked about that. The Employment Standards Act. What outlines the minimum? It's the common law. Okay, so they developed the time machine. And then they go in to see Isadora Izzet of the law firm of Izzet Unique and Howe. And she tells them how to protect it. Okay, but first of all, they get into some discussions, and she wants to invest in the business. So she said she might make a profit from her investment in the business. Why is that a problem? Because under the Partnership Act, which you can bring in with you, Section 32 says you cannot do that. She plans to build them directly and keep the fees. Rather than split it with their law firm, Section 33 says you cannot do it. Dr. Cooper Polly said, we would like you to invest, but we don't want to give up any voting control. Ms. Izzet says, I don't want any voting control, so what we should do is we should have two types of shares, common shares, preferred shares. You take the common voting shares, I get the preferred shares so that I get preference for dividends and repayment of capital. What aspects of the invention need protecting? It's called the egg timer, okay? Trademark, okay? Oh, but wait, there's two types. So I had one place with two lines, and that really confused people. So it's protected by passing off as long as you're continually using it in the trademark sense. It's protected under the Trademark Act if you register it. And how long does the protection last? 15 years, plus 15 years, plus 15 years, plus 15 years, as long as you renew. Okay, what else? Well, look at the unique shape. Wow. The shape should be protected by an industrial design. How long does the protection last? 10 years. Okay. The manual, copyright. So it's protected under the Copyright Act. Okay. How long is it protected for? The life of the author plus 50 years. Wait, no. Under the United States MCA, the new NAFTA, we have agreed that should be 75 years. Okay, just to really confuse you. The rest of the world, life plus 50 years. Under NAFTA, life plus 75 years until we change our Copyright Act. Okay. Then this, it's got to be unique, right? It's got to be ingenious, and it has utility. You're going to make money taking people on tours. And so there's a patent here. So how long does the patent last? 20 years. I got this idea because someone asked Dr. Stephen Hawking, who's recently passed away, but one of the most brilliant minds in astrophysics. They asked him, is time travel possible? And he said, no, it isn't. And they said, how can you be so sure? And he said, because where are the tourists from the future? If time travel was possible, people would be coming back on tours. Look at here is 2020 in Gibsons, BC. So anyway, that's how I got the idea for this problem. Okay, so they gave her a retainer, and after that, she sent them to see Mr. Cheatham. I guess the firm is Dewey, Cheatham and Howe. Anyway, Dewey is a name, and Cheatham is a name, a surname, and Howe is a surname. You put them together, Dewey, Cheatham and Howe, and you got the perfect name for a law firm. He asked what name they wanted for the company, and they called There and Back Again Travel Time, or Time Travel. And Cheatham explained that there was a problem with that name, and actually someone last year said it's too long. Anyway, the problem with the name is it doesn't end in Ltd Anchor Corp, so it's missing the legal element. After that was done, he explained that once incorporated, the four of them would have to ensure that the full corporate name was used on all materials, contracts, checks, and the name had to be posted on their business premises. Why? This person said copyright label. It's under the Corporations Act. You got it in the materials. Section 27 says that the corporate name has to be displayed. Okay? If you don't, you're liable as a director under Section 158, but I didn't ask that. Okay, he went on to say, you will be shareholders, directors, and officers. To prevent personal liability, you must be able to plead the something defense. You should know this, know this, know this. It's the due diligence defense. Okay, when you sign per the corporation, that's part of your due diligence. You're saying, I'm an agent for the corporation. You're protecting personal liability. You hire the best employees. You train them properly. That's your due diligence. It's spelled out in Section 142 of the BC Corporations Act, which states that you must use the care and skill of a reasonably prudent person. Dr. Cooper Polly said, it will be so exciting to be a partner with my friends. Cheatham responded, whoa, you're not partners. You say you are, you defeat the purpose of incorporating a company to protect yourselves from liability. Then you become liable as a partner, and you will have general joint liability and joint and several liability. So you never call yourself partners in a corporation. Okay? Cheatham then went on to explain 5 advantages of corporations over partnerships: continued existence, separation of ownership and management, limited liability, there are tax advantages, and there's no duty of goodwill or faith on behalf of the shareholders. Then they looked at insurance, and here I asked for, I think I said like 8 blanks, and that was too many. What kind of insurance should this business get? Well, you just sort of analyze it. They're going back in time. What happens if this product is negligently manufactured and they get trapped back there? Product liability insurance. You need event cancellation insurance because you collect money and you're going to take people back, and then for some reason you can't go. You want to have a rescue insurance, so maybe you've got money to build another time machine to go back and rescue people. You're in a corporation, you want heirs and omission insurance as directors. The only person that can fix the time machine is Howard Wolowitz, so you want to get key person insurance on him. They're going to, and this was later on in the problem, but it's a good example. People turn up and they say, okay, no, take all your personal belongings and leave them here. You cannot take them with you. And then they go on their time travel. They come back. Somebody's stolen their personal stuff. Well, you better have theft insurance, right? No, theft insurance covers things you own. It doesn't cover other people's assets left on your premises. So you have to have bailee insurance because they are the bailor, you are the bailee, and you cannot give them back in as good a condition, so you will be liable. Okay, so that's insurance. There are 2 other insurance-related issues. Look for these things. Is there a change in risk? Is Bob, the agent, actually the agent for them, or is he an agent for the company? Because if you say to Bob, hey Bob, I need the best policy, lowest premium, widest coverage, Bob will give that to you, but only the best policy that his company has. He's not going to say, oh, I can't do that. Go to another company. Okay, so he's not your agent. And then the other thing is, you get the insurance by phoning your agent. He says, you got it. Well, you don't. I mean, you do, as long as you can prove it. Okay, so you say, okay, send me a binder. Binder of insurance, a 1-page document that proves you have insurance. Leaving the law firm of Dewey, Cheatham & Howe, they go to sign is it a lease? Yeah, they're going to go sign a lease. How do they sign? Oh, I'm saying this so many times. The name of the corporation per a line with Authorized Signatory. What's the problem with that? It's a pre-incorporation contract, okay? So they may be personally liable. But he didn't know everything about it, because when the lease came in, there were some signature lines with seals beside their names as well as the corporate name. Pardon me, and that means they will be personally liable. Okay, then it ends with just before Cooper was to make the Egg Timer's maiden voyage, he asked Dr. Hofstadter to hold his limited edition mint condition Justice League of America comic book, which apparently the actors in The Big Bang Theory actually collect comic books. Okay, Leonard said, here, hold on to my book. Or Cooper says, here, hold my comic book, keep it safe for me. Bailment, right? So Leonard says, oh, what are my legal liabilities here? So Cooper says, well, it's a bailment situation. I'm the bailor, you're the bailee. You have to get it back to me in as good a condition as you got it. Bingo, bango, bong. That's last year's exam. This will be uploaded as soon as I can create a movie file and upload it to YouTube, so I'll get it on as quickly as I possibly can. Once you've done reviewing for the exam, email me with any questions. Thank you very much. That is everything.